Hello and welcome back to Ganga Education. On this platform, you will find quality lectures relating to the field of law, competitive examination in legal domain, important legal facts and legal history, all explained in clear and structured manner. In today's video, we are going to discuss section 88 to 92 of Bharatiya Nyaya Sanhita 2023, that is offense against women and children.
Today, we're going to tackle two really crucial sections from the Bharatiya Nyaya Sanhita 2023. That's Section 88 and Section 89, which both deal with the offense of causing a miscarriage. These sections are incredibly important for your judiciary and APO exams, so let's get right into the details. So, here's our game plan for today. We'll start with the basics, break down sections 88 and 89 one by one, see how they stack up against each other, look at some key court cases, and then wrap everything up with a super quick revision focused specifically on your exams. All right, let's dive right in with Section 88. Now, you should think of this as the foundation, the basic offense, when it comes to voluntarily causing a miscarriage. It essentially criminalizes the act of unlawfully terminating a pregnancy, but, and this is important, with some very specific exceptions. Okay, let's look at the actual language from the BEAR Act. I know legal text can be a bit dense, but in simple terms, here's what it means. If anyone intentionally causes a pregnant woman to miscarry and that act was not done in good faith to save her life, then that person is going to be punished. To really get this section, you need to understand three key ingredients, which you can see right here. First, woman with child. This is straightforward. The woman must be pregnant. Second, voluntary act. This means the act has to be intentional, not accidental. And third, and this is the big one, absence of good faith. This means the act wasn't done with the pure intention of saving the woman's life. Now, what does good faith mean here? It means an act done with all due medical care and attention for the sole purpose of saving the mother's life, nothing else. So, how does a court actually prove this offense? Well, the prosecution has to build a logical chain, step by step. First, they need to establish that there was a voluntary act. Then, they have to prove that this specific act led to the miscarriage. And finally, they must show that this act doesn't fall under the good faith exception. In other words, it wasn't necessary to save the woman's life.
Let's make this real with a practical example. Imagine someone secretly gives abortion pills to a pregnant woman. There's no medical reason for it, and it results in a miscarriage. This is a classic textbook case that falls directly under Section 88. It's a clear criminal offense.
Okay, now let's move on to Section 89. If Section 88 was the basic offense, think of Section 89 as the aggravated or much more serious version. This section comes into play when the miscarriage is caused without the woman's consent. And this slide really gets to the heart of the matter. The core difference between these two sections is just one powerful element: consent. You see, Section 88 is about causing miscarriage, but Section 89 kicks in when that miscarriage is caused without the woman's consent. This element of consent, or rather the lack of it, is what makes this a far more serious crime. So what does Section 89 say? It states that if someone commits the offense under Section 88 but does it without the woman's consent, the punishment is severe. We're talking about imprisonment for life, or up to 10 years, plus a fine. And why is the punishment so harsh? Because this isn't just about causing a miscarriage, it's a profound violation of the woman's bodily autonomy. All right, to really nail this for your exams, let's do a direct, head-to-head comparison of these two sections. This will give you a really solid structure for any comparative questions that come up in your mains.
Take a close look at this table. You'll notice the core offense for both sections is the same, causing miscarriage. But the key element, the legal trigger, is different. For Section 88, it's the absence of good faith. For Section 89, it's the absence of consent. It's that lack of consent that really escalates the gravity of the offense.
This bar chart makes the difference in punishment visually crystal clear. Under Section 88, the punishment is actually split. If the woman is not quick with child, meaning she hasn't yet felt the fetus move, the punishment is up to 3 years. But if she is quick with child, it can go up to 7 years. Now compare that to Section 89. When consent is absent, the punishment skyrockets to 10 years and can go all the way up to life imprisonment. The difference is absolutely massive.
Now let's look at some landmark case laws and legal principles. These are the court judgments that have really shaped how these sections are interpreted, and they'll help solidify your understanding.
A really foundational case here is Queen Empress versus Edema from way back in 1886. In this case, the court laid down a very clear principle: any intentional act that causes a miscarriage without a valid legal justification will be considered a criminal offense. It's that simple.
Fast forward to a more modern context. The Supreme Court's judgment in Suchita Srivastava versus Chandigarh administration is incredibly relevant. The court held that a woman's right to make reproductive choices is a fundamental part of her personal liberty, protected under Article 21. This principle directly reinforces why the consent element in Section 89 is so critically important.
There's also a key legal maxim that helps us understand the mindset behind these sections. Actus non facit ream nisi mens sit rea. It's a bit of a mouthful, but it simply means an act does not make a person guilty unless the mind is also guilty. You need a guilty mind, or mens rea. The requirement of a voluntary act in both sections is a direct application of this very principle.
Okay, let's shift gears now and get into our final segment, exam focus. This is where we'll talk about exactly how questions from these sections might show up in your Judiciary and APO exams.
These points are absolutely crucial for your preparation. In your prelims, you can expect direct questions about the punishment terms, or maybe about that click with child distinction in Section 88. For your mains, a comparative question between Sections 88 and 89 is a very common high-probability topic, and you'll often see problem-based questions that test your understanding of the good faith and consent exceptions.
All right, let's wrap this up with a super quick revision. Just remember these 4 key things. 1. Section 88 is about miscarriage without good faith. 2. Section 89 is about miscarriage without consent. 3. The key difference between them is that single word, consent. And 4. The punishment gap is huge, 3 to 7 years versus 10 years to life. Got it?
Before we go, I want to leave you with a question to think about. How does the good faith exception in Section 88 actually interact with the professional duties and the potential for negligence of a doctor or medical professional? It's a complex issue, so definitely give that some thought. For more legal content focused on your judiciary, APO, and law exams, please stay connected with us here at Gunga Education. Thank you for joining me.
Hello and welcome. Today, we're going to discuss a very important section of the Bharatiya Nyaya Sanhita, 2023, Section 90. This section deals with the serious crime where an act, done with the intention of causing a miscarriage, results in the death of the pregnant woman. In this explainer, we're going to cover these 5 key areas systematically. We'll start with an introduction to Section 90, then we'll break down its core ingredients. After that, we'll look at its practical application through case law, compare the BNS with the old IPC, and finally, we'll focus on the punishment and its importance from an exam perspective. All right, let's get started. Section 90 addresses that tragic situation where, in the course of committing one crime, a much bigger and unintended result occurs. You see, the intention here is to cause a miscarriage, but the outcome is the death of the woman. This is considered an extremely grave offense because it puts 2 lives at risk simultaneously, the life of the unborn child and the life of the mother. It's because of this double jeopardy that this section becomes quite important for your judiciary and APO exams. Okay, let's now break down the essential elements of this section. These are the legal ingredients that must be proven in court to establish the offense. The entire essence of this section is really captured in this one line from the bare act. So, in simple language, what does this actually mean? Well, it means that if a person performs any act with the intent to cause the miscarriage of a pregnant woman, and that act leads to the death of that woman, they will be held guilty under Section 90. There are a few key elements in this section. First, it's essential that the victim is a woman with child, meaning she must be pregnant. Second, the primary intention, or the mens rea of the accused, must be to cause a miscarriage. Third, their act, the actus reus, must have caused the woman's death. Fourth, if the act was done without consent, the punishment is much more severe. And perhaps most importantly, the offender cannot use the defense that they didn't know their act could be fatal. So, the crucial point is, the court generally looks for this chain of events to prove the offense. First, there was an act, and the intention behind it was to cause a miscarriage. Then, the direct result of that act was the woman's death. And finally, the consequence, which is the punishment, will depend on whether that act was done with or without her consent. So, we've covered the theory. Now, let's see how this section is applied in practical situations and through court judgments. Let's take a practical scenario. Imagine a person gives a pregnant woman an illegal or harmful medicine to terminate her pregnancy. That medicine causes fatal complications. and as a result, the woman dies. This situation falls directly within the scope of Section 90. A landmark judgment on this subject is the case of Emperor versus Adema. The main legal question in this case was this: can the accused be held liable for death when their only intention was to cause a miscarriage? The court answered with a definitive yes. It established the principle that when an attempt to cause a miscarriage results in death, the accused is responsible for that death. This quote clearly illustrates the core principle that came out of this case, and it's something you should definitely remember. Criminal liability arises even if the death was an unintended consequence of the attempt to cause a miscarriage, even if causing death wasn't the original intent. We can also understand this principle through a legal maxim, ignorantia facti non excusat, which means ignorance of fact is no excuse. The explanation in Section 90 says exactly this. The offender cannot escape liability by claiming they were not aware of the fact that their act could be fatal. Now, let's see where this provision in the new law comes from and how it connects to the old Indian Penal Code. So, this provision was earlier found in Section 314 of the Indian Penal Code. It is now then placed under Section 90 of the BNS 2023. Functionally, the concept is exactly the same, only the section number has changed, which is of course a very important detail for your exams. We're now at one of the most crucial parts of this explainer, what the punishment is under this section and what you really need to remember for your exams. The punishment under Section 90 is divided into two parts, based on consent. If the act is done with the woman's consent, the punishment is imprisonment for up to 10 years and a fine. However, if the same act is done without her consent, the punishment is far more severe, imprisonment for life or for up to 10 years and a fine. This difference really shows how much importance the law gives to a woman's consent and her bodily autonomy. Now, for an important exam tip. In the prelims for Judiciary and APO exams, you can expect a direct question from this section. In the mains, you might be asked to write a short note on it or solve a problem-based question. For a quick revision, just remember these three things. The section number is 90, the core concept is death resulting from an intended miscarriage, and the most important distinction is that the punishment varies based on the woman's consent. Before we wrap up, I want to leave you with a question to think about. How does Section 90 strike a balance between the intent to commit a lesser offense, that of miscarriage, and the tragic, unintended consequence of death? I encourage you to reflect on this legal principle. For more essential legal content focused on judiciary, APO, and other law exams, please stay connected with Ganga Education. Thank you. Hello, everyone, and welcome. Today, we're going to dive deep into Section 91 of the Bharatiya Nyaya Sanhita 2023. Now, if you're preparing for the Judiciary or APO exams, this is one section you absolutely need to pay attention to. It covers the very serious and sensitive topic of acts intended to prevent a child from being born alive. So let's get right into it and break down exactly what you need to know. All right, here's how we're going to tackle this. First, we'll get a solid grip on what Section 91 is all about. Then we'll break down the essential ingredients of the offense. After that, we'll look at some real-world applications and cases, check out the punishment, and finally wrap it all up with some key takeaways specifically for your exams. Ready? Let's get started. Okay, first things first. Let's really understand the heart of Section 91. What's its main job? Well, its fundamental purpose is to protect a potential life even before it gets a chance to start outside the womb. You see, this is a really important principle in criminal law. It sets up a legal shield right at the very earliest stages. So, the BARE Act says, and I quote, "Whoever before the birth of any child does any act with the intention of thereby preventing that child from being born alive or causing it to die after its birth shall be punished." It sounds a bit technical, right? But it's actually pretty straightforward. Basically, it's saying that if someone does something before a child is born with the specific goal of either stopping the baby from being born alive or making sure it dies right after birth, and their action actually causes that to happen, well, then they're going to be punished. Now, to really get this, we need to do what a court does, break the offense down into its essential ingredients. Think of it like a recipe. You need all the right components to prove the crime. So let's take a closer look at what makes up an offense under Section 91. Okay, so there are four, let's call them pillars that hold this offense up. First, the act has to happen before the child is born. That's a clear timeline. Second, and this is super important, there has to be a specific intention, what we lawyers call mens rea, or the guilty mind. The person must want to prevent the live birth. Third, The action must actually cause the tragic result. Either the child is stillborn or dies right after birth. And finally, number 4, the act was not done in good faith. This good faith part is a huge exception, and we'll talk more about it in just a bit. This flowchart here gives you a perfect visual of how a court thinks through these cases. It's like a checklist. First, they ask, was there an act before birth and was there intention? Check. Then, did it cause the prohibited result? Check. Finally, they look at the good faith exception. If that doesn't apply and all the other boxes are ticked, only then do they move on to considering punishment. It's a very logical process. Okay, enough with the theory for a moment. Let's see how this all plays out in the real world. We're going to bring this section to life with a practical example, a landmark case, and a key legal maxim you should know. All right, let's imagine a scenario, the kind you might see in an exam. Suppose a person gives a pregnant woman a specific substance. Their clear intention is to terminate the pregnancy and ensure the child doesn't survive. And as a direct result of that substance, the child is tragically stillborn. In this case, do you see how all the ingredients of Section 91 are met? The act, the intention, the result. It's a textbook application of this law. To truly understand a law, we have to look at how courts have interpreted it over time. And for this section, a foundational case, even though it's quite old, is R versus Senior from 1832. The principles laid down here are still incredibly relevant for understanding this offense. So, what was the main issue in this case? The big question was, can stopping a newborn from taking its very first breath be considered a criminal act? And the court's answer was a resounding yes. The principle that came out of this was crystal clear. Intentionally destroying an infant's life right at the stage of birth is a serious crime and carries serious legal consequences. Remember that good faith exception we talked about? Well, this leads us to a really important legal maxim, bona fide. It's Latin, and it simply means in good faith. The law is practical. It understands that sometimes a doctor might have to perform a procedure to save the mother's life, even if it tragically risks the life of the unborn child. If that act is done genuinely, for that specific purpose, it's considered bona fide. And if it is, it's a complete defense against Section 91. This is an absolutely critical point to remember. Okay, so we've covered what the offense is and how it's applied. Now let's talk about the consequences. What happens if someone is found guilty? We'll look at the punishment laid out in the BNS and also how this law has evolved from the old IPC. Now, this is a super important update for all exam aspirants. This provision used to be under the old Indian Penal Code, or IPC, but now it's Section 91 of the new Bharatiya Nyaya Sanhita 2023. So please, in your exams, make sure you're citing the new section number. That's a detail you can't afford to get wrong. So what exactly is the punishment? Well, anyone convicted under Section 91 can face imprisonment for a term that could go up to 10 years. In addition to that, or instead of it, a fine can be imposed, or it could be both. The court, of course, has the discretion to decide the sentence based on the facts of the case. All right, let's bring it all home. This is probably the most important part for your exam prep. We're going to condense everything we've just discussed into some quick, powerful takeaways for your Judiciary and APO exams. Listen up, because this is gold for your exams. For the prelims, you can almost guarantee you'll get a direct question on the section number, that's Section 91, and its punishment. Also, be ready for a question about the good faith exception. Now, for the mains, things get a bit more complex. Expect problem-based questions, where they give you a situation, and you have to apply the ingredients we talked about. A short note on this offense is also a very common question, so be prepared for that too. Okay, time for a super quick recap. If you remember nothing else, remember these key points. What's the section? Section 91 of the BNS 2023. What's the core idea? It punishes acts done before birth to stop a live birth or cause death right after. What's the main exception? Acts done in good faith to save the mother. And the punishment? Up to 10 years, a fine, or both. Got it? Good. When you really think about it, Section 91 is all about a profound legal and ethical balancing act. It's about protecting potential life while at the same time making sure the mother's safety is paramount. It really makes you think about the question, when does life legally begin? That's a massive concept you'll grapple with throughout your legal career. Thanks so much for joining me today. For more deep dives like this to help you ace your exams, make sure you stay connected with us here at Ganga Education. Hello, everyone, and a very warm welcome to Ganga Education. Today, we're diving into a really significant section of the Bharatiya Nyaya Sanhita 2023. We'll be breaking down Section 92, which deals with the very serious offense of causing the death of a quick unborn child. So let's start with the big legal question at the heart of this section. What happens when an act that falls under the category of culpable homicide, results in the death of an unborn child instead of the person? It's a complex situation, isn't it? Well, Section 92 of the BNS is here to give us the exact legal answer. All right, so Section 92 is classified under the chapter on offenses affecting the human body. Now, for everyone preparing for the Judiciary and APO exams, this is a section you really need to know well. It's quite important, so let's pay close attention to the details. To understand this section, we first have to get a handle on the term quick unborn child. It's very specific. In the language of the law, this means a fetus that has developed enough for its movements to actually be felt by the mother. This isn't just a detail, it's a key precondition for this section to even apply. Now let's look at the language straight from the bare act. In simple terms, what this is saying is this. If a person commits an act, and if that act had resulted in the death of a person, they would be guilty of culpable homicide. But if that same act instead causes the death of a quick unborn child, then Section 92 comes into play. To really understand this offense, let's break it down into its 4 essential ingredients. First, the act must be serious enough to amount to culpable homicide. Second, the victim must be a quick unborn child. Third, the act must be the direct cause of the fetus's death. And fourth, the accused must have the necessary mens rea, the intention or knowledge required for culpable homicide. This flowchart here shows us the logical sequence a court follows to prove this offense. It starts with step 1, an act is committed. Then in step 2, the prosecution must prove the essential ingredients, the actus reus and the mens rea. Once those are proven, we move to step 3, where guilt is established under Section 92. And finally, step 4, the punishment is awarded. Okay, let's make this crystal clear with a practical example. The BNS itself provides an illustration to help us understand, so let's imagine this situation. According to the illustration, a person A commits an act that was so dangerous it was likely to cause a pregnant woman's death, but the woman survives. However, her quick unborn child dies as a result. In this case, A will be held guilty under Section 92 because the act itself contained all the necessary elements of culpable homicide. Now, let's look at a landmark case that set a crucial judicial precedent for interpreting this section. The case is Emperor versus Adedema from way back in 1886. In this judgment, the court held that if a person commits a dangerous assault on a pregnant woman and it leads to the death of her unborn child, the accused can't escape criminal liability. The court reasoned that the dangerous nature of the act itself was sufficient to establish the kind of criminal intent needed. This principle is closely linked to the legal maxim res ipsa loquitur, which means the thing speaks for itself. In the context of this section, it implies that a dangerous act against a pregnant woman, on its own, points towards negligence or criminal intent. The act's nature says it all. So what about the punishment? Under Section 92, anyone found guilty of this offense faces imprisonment for a term that can extend up to 10 years, and they will also be liable to a fine. It's a serious, non-bailable offense. Now for some exam tips. From a Judiciary and APO exam perspective, in the prelims, you can expect direct questions, maybe on the section number or the definition of quick unborn child. In the mains exam, however, you should be ready for problem-based questions that require you to analyze all the ingredients, or you might be asked to write a short note on Section 92. All right, for a quick revision, just remember these 3 key things. First, the section number, Section 92 of the BNS. Second, the core concept. It punishes an act amounting to culpable homicide that causes the death of a quick unborn child. And third, the punishment, up to 10 years imprisonment and a fine. For more legal content focused on Judiciary, APO, and other law exams, stay connected with us here at Ganga Education. Thank you for joining me.
Thank you for watching this session. If you found this lecture useful, do like, share, and subscribe to Ganga Education. Keep learning, keep growing, and stay connected for more law lectures.